In late August 2022, a district court judge in Oklahoma ruled that a convicted felon could not own a gun. A few weeks later, in a separate case in Texas, another district court judge ruled the opposite, that a convicted felon could own a gun. That judge said a law prohibiting convicted felons from exercising their Second Amendment rights was unconstitutional. Two lower court judges, same issue, two different conclusions. It's not that uncommon. But the thing that is new, both were using a novel test for analyzing gun laws that the Supreme Court created in a recent decision.
How are lower courts dealing with Bruan? The answer is badly.
Bruan is New York State Rifle and Pistol Association v. Bruan, a case the Supreme Court decided in 2022. Amid a spate of mass shootings and heated debates over gun rights, Bruan was an opportunity for the Supreme Court to provide clarity to lower courts on how to analyze gun laws. That's not what happened.
In a 6-3 decision, the court struck down New York's law, which places restrictions on concealed handguns.
The majority opinion, written by Justice Clarence Thomas, held that New York's law was unconstitutional. His reasoning? It deprived New York citizens of their Second Amendment right to own a gun for self-defense. But Thomas went even further.
The majority in Bruan says that all gun regulations in the United States need to be analyzed to see if they comport with some tradition, some history of American gun regulation.
Darrell Miller is co-director of the Duke Center for Firearms Law. He says, prior to Bruan, when considering a law that impacted the rights of gun owners, lower courts used a test that asked whether the law advanced an important government interest, like public safety.
What is the reason that you have this regulation? How well does it work? If it accomplished the purpose to which the law was enacted and didn't sweep in too much protected activity, then the court would uphold under what was known as intermediate scrutiny.
Bruan changed all that. The court adopted a new test, whether a law is consistent with the nation's historical tradition of firearm regulation. In other words,
the intentions of somebody like James Madison or Alexander Hamilton should control what the Constitution means and the legal content of the Constitution.
This is called the Text, History, and Tradition Test. As part of this new test, judges evaluate laws that restrict gun rights by finding similar or analogous historical laws. That may sound straightforward, but rulings coming from lower courts show it has been anything but.
You're getting lots and lots of conflicting decisions using this sort of history and tradition analysis. You have some courts saying that you can keep felons from having guns. You have other courts saying you can't. You have some courts saying that large capacity magazines can be banned. You have other courts saying that they can't.
Why are judges having such a hard time applying this test?
Judges are generalists. They're not historians. They aren't steeped in the way people behaved, operated, understood things in the 1700s.
In his dissent to Bruan, Justice Stephen Breyer noted one major challenge. How do laws addressing ancient weaponry inform how a judge should rule on laws addressing modern guns? Another issue? History isn't always so clear.
The lawyers and the judges might not even know what the historical materials are. They don't know what the tradition is. It might be hard to unearth.
Which means courts are turning to the experts who are steeped in those things. Saul Cornell is an historian and professor at Fordham University. And David Kopel is a constitutional expert on guns and adjunct professor at the University of Denver's Sturm College of Law. They both filed amicus briefs in Bruan on different sides.
If nobody has firearms, then a country could easily be overrun by some foreign tyrant or a military dictatorship.
Regulation is not the opposite of liberty.
We asked the professors for historical arguments for and against one scenario in particular where guns should be allowed. It was on the justices' minds during oral arguments in Bruan.
New York City subways.
By subway. Subway.
Under Bruan, how should judges evaluate a ban on guns on mass transit, which of course didn't exist at the country's founding? Challenge number 1, finding an analogy.
Do we go looking at stagecoaches, at riverboats? What are we supposed to analogize?
You might say subways are fairly similar to railroads. And so what were the laws that did or did not ban people from being able to lawfully defend themselves on a railroad.
Challenge 2, determining the meaning of the historical law at the time it was enacted.
There were some regulations about guns on trains in the early 19th century, and that does seem to provide a good analog for New York City's law against having guns on the subway.
If you look at the various laws about guns and trains, there were things that said, for example, in some states, if you're a passenger on a train, don't shoot out of the window of the train at whatever the train happens to be passing. But that's very different from saying you can't even possess a firearm for protection on the train.
So, where does this leave things?
Lower courts are really struggling with figuring out how to apply this history and tradition test to modern problems like guns on airplanes or assault rifles.
In its October 2023 term, the Supreme Court heard its first gun case since Bruan.
The U.S. Supreme Court heard arguments today in a major case looking at whether people with domestic violence court orders should be barred by federal law from owning guns.
The majority of the justices expressed a reluctance to strike down the federal law, signaling that gun rights may have some limits. One thing is clear. After upending decades of how courts analyze gun laws in America, there will likely be many more cases to come.
We're actually in for a fairly long period of turmoil in terms of Second Amendment litigation. A lot of the judges that were appointed, especially during the Trump administration, really believe in this sort of text, history, and tradition approach, and they aren't swayed by the fact that there are actually many, many laws that have been on the books for sometimes 100 years that should be preserved. We're going to get a lot of surprising decisions by lower courts, and the Supreme Court's going to have to weigh in many times.